Welcome to the Regulatory Transparency Project's fourth branch podcast series. All expressions of opinion are those of the speaker.
Hello, and welcome to the Regulatory Transparency Project's fourth branch podcast explainer episode number 82. Today, we are joined by Greg Baylor, who is an attorney with Alliance Defending Freedom, where he is the director of the Center for Religious Schools and senior counsel with the Center for Public Policy, as well as Rachel Morrison, a fellow at the Ethics and Public Policy Center. These experts will have a discussion on the administrative and judicial reinterpretation of disability. Thank you both for joining us, and I'll pass it off to Rachel. Thank you for joining us, Rachel.
Thanks, Marie. It's great to be here, and I'm so glad that we have Greg to discuss disability discrimination and how it relates to gender dysphoria. So first off, Greg, I think it would be important if we can just let folks know what federal non-discrimination laws are that prohibit disability discrimination.
Yeah, sure. Let me start by saying, thanks for inviting me, and it's a real pleasure to be on and participate in this conversation. There are a couple of federal statutes a couple of primary federal statutes that deal with disability, specifically discrimination on the basis of disability. The one that was enacted first was the Rehabilitation Act, enacted back in 1973. The second one is the Americans with Disabilities Act. People may be more familiar with that one. It was enacted back in 1990. And there's similarities between them and differences between them. One of the ways they're similar is that, of course, they both ban discrimination on the basis of disability. Both of the statutes define disability in essentially the same way. Both impose not just a non-discrimination obligation, but also an obligation to provide reasonable accommodations for disability. And they're similar in how they're enforced. It's sort of a combination of agency action and the courts. But they are different in some ways. The Rehabilitation Act, specifically the non-discrimination piece, Section 504 of the Rehabilitation Act, is a condition on federal benefits. It doesn't just apply to you because you're present in the jurisdiction. It's sort of an exchange. If you want to get a federal financial assistance, one of the laws you have to comply with is Section 504 of the Rehabilitation Act. So you have to be a recipient of federal financial assistance to even be subject to Section 504. By contrast, the Americans with Disabilities Act, you might call it a police power statute. It really depends on whether you're present in the jurisdiction, which is the United States, and you satisfy the definition of the type of entities that are covered. For example, the ADA has an employment title. It has a title that applies to state and local governments. It has a title that applies to public accommodations, and one applies to telecommunications. But you don't have to be a recipient of federal money in order to be subject to the ADA. One of the other ways that they differ is that the ADA takes religious entities into account. In the employment title, there is an exemption for religious employers, whereas there is nothing in the Rehabilitation Act that deals with religious entities. Another way that the ADA accounts for religious entities is that it categorically excludes them from the definition of places of public accommodation. So Title III of the ADA is not applicable to, say, churches and social service ministries that are religious. So those are some similarities and some differences.
So relevant for our discussion today, we're focusing on the definition of what is a qualified disability. You said that they're functionally similar between Section 504 and the ADA. Can you let folks know what that definition is?
Yeah, sure. The precise definition is, and I'll read it, is a physical or mental impairment that substantially limits one or more major life activities of an individual. So it's a physical or mental impairment and substantially limits one or more major life activities. The only difference is there are some parts of the Rehabilitation Act that are specific to the employment context. So they talk about undermining the person's ability to perform a job. But for the most part, they're the same definition. The definition includes in part this mention of the phrase of major life activities. That includes a variety of things, physical activities, cognitive functions, sensory functions, and bodily functions. So, that's the basic definition, but both statutes have a long list of exclusions from the definition, 15 in fact. There are things like illegal drug or alcohol abuse, kleptomania, pyromania, compulsive gambling. And then there are a bunch that are somehow related to sexuality. And that's obviously going to play a significant role in our conversation today. The things that are excluded include homosexuality, bisexuality, transvestism, transsexuality, pedophilia, exhibitionism, voyeurism, and here's the language that's really significant to our conversation today: gender identity disorders not resulting from physical impairments. So gender identity disorders not resulting from physical impairments. And then there's sort of a catch-all at the end that says other sexual behavior disorders. So there's a basic definition and then a series of exclusions, including ones that relate to sexuality and gender.
And are any of those terms defined that are in the exclusion list that you just read? Or
no, the
ones that we're focusing on?
No, they don't. They don't define them. So they're just left to the normal tools of statutory construction rather than relying upon a particular definition that's in the statute.
So currently there's this ongoing debate about whether gender dysphoria, which is not a term that you mentioned explicitly in the list of exclusion, is a qualified disability or whether it falls under one of the other terms in the list of exclusions from the definition of qualified disability. Can you explain an overview of the arguments on both sides and how this debate has come out?
Yeah, sure. So, this debate about whether gender dysphoria is a qualified disability under these statutes became possible in the first place because of changes in the everyday language that we use to describe these phenomenon. When I was reading the statutory text, you heard words like transvestism and transsexuality. Those are words that, we don't hear as often anymore. One of the other changes that happened in everyday and in more technical language was the rise of the term gender dysphoria. It began to become the customarily used term for what used to be called gender identity disorder. Now, the phrase gender identity disorder, it's a statutory phrase, but it's also a phrase that's been in the past, at least in the American Psychiatric Association's Diagnostic and Statistical Manual. In 2013, the APA revised the DSM and issued the new version, the DSM-5, and they eliminated the term gender identity disorder from the DSM-5 and then added the term gender dysphoria. And at that time, a lot of observers perceived that this was simply a substitute, right? That they were both referring to the same things. It was just a different term referring to the same phenomenon. But later, people started to argue that gender dysphoria was something distinct from gender identity disorder. In the DSM, gender identity disorder was characterized by two things. It was characterized by a persistent identification as the opposite sex, plus the distress and anxiety that accompanied that. What gender dysphoria is, at least according to those who make the argument that these are distinct terms, is that gender dysphoria is exclusively about the distress and the anxiety. Now, it presupposes that there's cross-sex identification, but the cross-sex identification itself is not part of the DSM's definition of gender dysphoria. It's common knowledge that one of the reasons this change was made was to make an effort to sort of destigmatize the status of being transgender. So you don't want to call it a disorder if you want to destigmatize it. So that's sort of the background to it. Now, what does all this have to do with the interpretation of the statute? And that's a great question. Those who would argue that gender dysphoria is not a gender identity disorder and thus can be a disability would say that these are distinct things, that the exclusion of gender identity disorders does not exclude gender dysphoria. Essentially, when the DSM changed or eliminated, rather, the term gender identity disorder, the corresponding language in the statute became a nullity. It means nothing. It doesn't exclude anything. That's the argument that's made on that side of the debate. Another argument that proponents of the idea that gender dysphoria is a disability for purposes of Section 504 and the ADA is that it does, in fact, result from a physical impairment. Remember, the exclusion in these statutes from the definition of disability, it's not all gender identity disorder. It's gender identity disorders not resulting from physical impairment. So you see arguments that to the extent gender dysphoria is a gender identity disorder, it is caused by or results from a physical impairment. And thus can be, I know this is confusing, and thus can be a disability. It's outside the scope of the exclusion. The arguments for this, they're stronger or weaker depending on what you're reading. But, some of the arguments, they focus on the fact that mental distress can have physical manifestations, which is true. They also focus on the fact that some of the treatments for gender dysphoria, so-called treatments for gender dysphoria, like the administration of puberty blockers or cross-sex hormones or the performance of surgery, that those are physical things. And given those two realities, physical manifestations of the disease and physical treatments, that therefore it must be caused by something physical. Now, in my judgment, that doesn't follow, and some courts have agreed with that view. Another argument that we see made for the proposition that gender dysphoria is not a gender identity disorder and is a disability is that it doesn't fall within this catch-all phrase. Remember, the list of exclusions included, quote, other sexual behavior disorders. And, there's an argument that, well, okay, maybe gender dysphoria is not a gender identity disorder, but it is some other sexual behavior disorder. And, there's a debate about whether that's true. Now, the whole argument sometimes gets colored by sort of constitutional implications. There have been arguments made that the existence of this exclusion of gender identity disorders, of transsexuality or whatever, that violates the Equal Protection Clause, that it's a classification, an impermissible classification that doesn't satisfy the requisite level of scrutiny. And the way that plays into the statutory interpretation question is the advocates will invoke the doctrine of constitutional avoidance. They will say, in order to avoid this potential constitutional question, let's interpret the statute in such a way so that we don't have to confront it. The other side of the argument, it's kind of implicit in a lot of what I said about the argument on one side. The basic idea is that gender dysphoria is a gender identity disorder, and that doesn't have a physical cause. The idea is that the meaning of a statutory phrase does not depend on the definition or the changing interpretation in a separate document. APA Diagnostic and Statistical Manual, that document doesn't get to control the interpretation of a statute. And also, you interpret statutes, their meaning at the time they were adopted. They also make the argument that it's not just gender identity disorder, singular in the statute, it's gender identity disorders, which suggests that it's something beyond sort of strictly and technically, quote, gender identity disorder, as that term appears in the DSM. As far as the constitutional avoidance argument, the argument is that doesn't even apply because you only resort to that when the statute is ambiguous or vague. And, the idea here is that it's not ambiguous. So the constitutional consideration doesn't matter. And, going to this issue of whether there's a physical cause, like I said before, it doesn't seem to follow that just because there are physical manifestations of gender dysphoria and there are physical treatments for gender dysphoria, it has a physical cause.
To follow up on that, do you have any insights on why Congress added the not a result of a physical impairment, or like what that was supposed to actually qualify as a disability that was a gender identity disorder?
Yeah, I confess that I haven't studied the legislative history closely, but I have a speculation, and maybe you have a different answer. But there is such a thing as disorders of sexual development. Sometimes we use the phrase intersex, and these are conditions that can have anatomical consequences. And you can see why there might be sort of psychological consequences or follow-ons from, an ambiguity in the genitalia or something like that. And I think Congress was trying to account for that and say that can be a disability. We want to set that aside, but we don't want sort of cross-sex identification or the distress that accompanies it by itself to be a disability.
That's my gut instinct as well. I haven't seen much written on it, but that would be my guess as far as what they were thinking. I guess another follow-up is there's been this effort to expand sex discrimination to include transgender status, gender identity. How does gender identity, transgender status, gender dysphoria overlap or not?
Yeah, well, I think it does. I think in a lot of ways you end up in the same place legally. So as you've mentioned, there have been, largely successful efforts to redefine the term sex, or at least redefine the phrase discrimination on the basis of sex, to reach discrimination on the basis of sexual orientation and gender identity. The most prominent example of this phenomenon is the Bostock case. The Supreme Court in 2020 held that Title VII's ban on sex discrimination reached SOGI, or sexual orientation, gender identity discrimination. You might say that there's a distinction between gender identity and gender dysphoria. And that may well be true, but I think when people make allegations of gender dysphoria discrimination or failures to accommodate gender dysphoria, they make exactly the same arguments when they're claiming something is gender identity discrimination. For example, if you deny a trans-identifying person access to a private space that's consistent with their gender identity or their asserted gender identification rather than their biological sex, they will say that is gender identity discrimination for purposes of, say, Title VII or Title IX. They will also say that's gender dysphoria discrimination for purposes of the ADA and Section 504.
It seems that not everyone who identifies as transgender or has a gender identity that doesn't align with their biological sex may or may not have a gender dysphoria diagnosis. So it seems like the diagnosis of gender dysphoria might be a significant aspect in disability discrimination. But to the extent that it might be easy to get that diagnosis, it might be just a small hurdle folks might have to face in order to receive protections, assuming the disability discrimination laws apply to gender dysphoria. So yes. You mentioned this a little bit as far as how these claims often are used interchangeably to achieve some of the same things. So what are some of the things or some of the benefits that folks who have gender dysphoria would and are seeking to obtain through disability discrimination laws?
Yeah, like I hinted at, it's the same kind of litigation objectives that you see when someone's asserting gender identity discrimination under Title VII or Title IX or Fair Housing Act or whatever. So, of course, there's just sort of straight up status discrimination. A person says they're gender dysphoric and someone takes an adverse action against them simply because that they have that condition. And we're not talking about anything else, just their, the condition or the status of having gender dysphoria. But I think the most significant things, at least for purposes of our conversation, are what goes beyond that. So folks will argue that, like I said, the denial of access to private spaces based on asserted gender identity rather than biological sex, that is either gender dysphoria discrimination or it's a failure to reasonably accommodate somebody's gender dysphoria. Other arguments focus on the use of preferred pronouns. The idea being that, the failure to use a trans-identifying person's preferred pronouns creates a hostile environment, constitutes discrimination. Another thing you see argued is that the denial of treatments or medical and psychological responses to gender dysphoria. Someone decide a doctor or healthcare provider that does not want to administer puberty blockers, cross-sex hormones, or perform surgery as treatments for gender dysphoria. The idea would be like, look, you're violating Section 504, you're violating the ADA. Most employers these days have health insurance plans for their employees, and we've seen allegations that excluding so-called sex reassignment, puberty blockers, cross-sex hormone surgeries, that the exclusion of those things from health plans constitutes gender dysphoria discrimination. One application, it's come up in only one case. You see it in the Title IX context, the idea being that to avoid committing gender identity discrimination under Title IX, you have to allow boys who identify as girls and men who identify as women to participate in girls' and women's sports. You see that same argument, again, at least in one case, where someone is saying that Section 504 of the Rehabilitation Act and the ADA make illegal a state statute, this one in Arizona. Arizona is one of a number of states that have these statutes that, assign people to interscholastic athletics based on their biological sex rather than their asserted gender identity. So it has a lot of the same implications, consequences, arguments that you see in arguments about gender identity discrimination in Title VII and Title IX.
So it's come up in education, it's come up in employment. What other context has these gender dysphoria, disability discrimination lawsuits and claims been raised?
Yeah, you see, there's a significant portion of these cases arise in the prison context. There are inmates who are in the custody of the state who are biologically one sex, but they identify as the opposite sex. And, they seek things as a consequence of that. For example, a male prisoner who identifies as female may request to be placed in a women's prison, or may request that female commissary items be made available to them, or that strip searches be done by a person who matches their gender identity rather than a person who matches their sex. Access to medical treatments, that's obviously a big thing in prison because the prison itself is responsible for the provision of medical care. And there have been cases where jails or prisons have either restricted or limited or denied the kind of medical interventions that transgender identifying individuals often seek, like hormones and surgeries and the like.
It seems like the disability discrimination laws are much more cross-cutting against different areas, whereas Title IX just applies to education, Title VII just applies to employment. Section 1557 of the Affordable Care Act incorporates in these disability discrimination laws, and so that applies to healthcare. And so the disability discrimination laws have a broad import across the board. And it seems like whatever is said about sex discrimination or the 14th Amendment those are separate arguments. So even if sex discrimination doesn't cover gender identity or transgender status, or the 14th Amendment doesn't apply to those as well, there could still be claims raised in the disability context that achieve some of the same goals, but through a different means. And so it's a separate question, even though it is related, and maybe the end result might be the same.
If I could just interject one point there, I'll just say, amplify that a bit. The Constitution obviously restrains the government. And while it's true that Section 504 and the ADA apply in part to government agencies, they also apply to non-governmental agencies. There were probably hundreds of thousands of non-governmental agencies that receive federal financial assistance, including almost every college and university in the country. And of course, the ADA, by its own terms, applies to employment and public accommodations and telecoms, which tend to be private entities. So you're making a good point there about the reach of these statutes, especially as compared to the Constitution.
So how have courts addressed these claims? There's been litigation over the years. It seems like there's been a lot more litigation in the last several years, as more and more folks have been diagnosed with gender dysphoria and are identifying with different gender identities. How have courts addressed this historically, and then has there been a shift from years ago to today?
Yeah, I mean, like I said before, even the availability of this debate or the existence of this debate turned to some degree on the change in nomenclature, both in sort of common conversation and more technically in the DSM. So you started to see litigation on this question arising in around the same time period. I don't know if this is the first case, but I think it's the first case. There was a case out of Ohio that was litigated in 2003. It was an employment case, and the employee was trans-identifying and made the argument that they were entitled to use. It was a man. He was arguing that he was entitled to use the women's restroom, and they denied that to him. And he alleged that this was a discrimination under the ADA, and this issue of whether gender dysphoria, and he said, I have a diagnosis of gender dysphoria, whether that could be a disability came up, and the court said it didn't. But it really kind of picked up later, especially after the DSM-5 was released in I think 2013. And then, transgender issues became more prominent as part of the public discussion in this country. The earlier cases tend to reach the conclusion that gender dysphoria was not a disability. More recent cases are more likely to say that it is, or at least can be, a disability. I haven't counted all the cases. There's at least 15, and the ratio seems sort of be about 2 to 1, whereas, two-thirds of the decisions are saying gender dysphoria can be a disability, and the other third are saying it's not a disability. And again, relying on the arguments that we already discussed on the respective sides.
So obviously the Supreme Court hasn't determined this issue for us. Are there any circuit court opinions, and what have they said?
Yeah, there's one that I'm aware of. I don't think there are any others. The Fourth Circuit is the only circuit to have addressed this issue straight up. It's a case called Williams versus Kincaid. In this case, involved a jail. It was actually an inmate at the Fairfax County Jail here in Virginia, where I live. And the inmate was trans-identifying, a male who identified as female. And the sheriff, who's the representative of the jail and the main defendant, did not provide him the sort of things that he wanted, access to female housing, strip searches by the appropriate sex, access to undergarments appropriate or matching his gender identity in the commissary. This person also alleged that there were delays in the treatment, hormone treatments for that this person was taking his treatments for gender dysphoria. So the inmate filed a lawsuit under both the ADA and Section 504. Unsurprisingly, the Fairfax County Jail receives federal financial assistance, so it's subject to 504. It's also a state and local government, so it's subject to the Americans with Disabilities Act, Title II specifically. And then we were off to the races. The argument that the sheriff made in part in defense was that, well, you said you're diagnosed with gender dysphoria. That's not a disability. Look at the exclusion in the statute. It's a gender identity disorder. It doesn't result from a physical impairment. The district court accepted that argument. Case goes up to the Fourth Circuit in 2022, and a divided panel says that gender dysphoria is, or at least can be, a disability, for purposes of the ADA and Section 504. So that's the leading case. The arguments are those sort of the ones that we discussed before, that, gender identity disorder is gone, like the DSM term is gone, and therefore the statutory term is gone. The physical impairment thing, they pointed at the physical manifestations of gender dysphoria and the physical nature of the treatments. And also, the constitutional question is a kind of a thumb on the scale to interpret it that way. There was a dissent that I thought was powerful, and the Supreme Court was given an opportunity to address this case. A cert petition was filed. The cert petition was denied, but there was a published dissent by Justice Alito and Justice Thomas. And, they raised the possibility first that the Fourth Circuit's majority's analysis was incorrect. But then they started to spin out some of the consequences and how really significant this conclusion is. It seems like a small technical thing, but given the reach of the ADA, given the reach of Section 504, and given what people argue constitutes gender dysphoria discrimination, they said this is something really significant and we should take it up. But again, the court denied cert, so we haven't heard from them yet other than those two dissenters.
Well, I'm sure there will be more opportunities probably in the not too distant future for the Supreme Court to choose whether or not to address this issue. What has been the Biden administration's response and their position on gender dysphoria discrimination protections?
Yeah, so overall, they take the position that gender dysphoria is a disability. That's sort of the starting point, and this conclusion has manifested itself in a variety of settings. Back in 2022. This is when some states in earnest started questioning the propriety of using puberty blockers, cross-sex hormones, and surgeries on children, and hinted or went ahead with restrictions or regulations on that. The Biden Department of Health and Human Services, their Office for Civil Rights, sent out a notice in March 22 saying, hey, those kinds of things that you've either already done or are considering could violate Section 504 or the ADA. Just a few weeks later, there was a similar missive that was sent out by the Department of Justice, the Civil Rights Division. They sent a letter to all state attorneys general sort of making the same argument. Look, if you're going to, and the way they characterized it is restrict access to health care for gender dysphoric kids, that you're going to be violating Section 4 and/or the ADA. The Department of Education got in the act too. They, in November of 2022, they sent out a notice to sort of regional enforcement people saying, hey, look, if you've got a situation involving, a transgender student who's protected by Title IX, don't forget that you have an alternative legal theory or alternative legal theories under Section 504 and the ADA. The administration got, I would say, more aggressive as time went on in 2023. The HHS's Office for Civil Rights sent a letter to the South Carolina agency that administers its Medicaid program and told South Carolina that the exclusion of so-called gender-affirming care, puberty blockers, cross-sex hormone surgeries from Medicaid possibly violated Section 504 of the ADA. We've seen statements in litigation when the constitutionality of the exclusion has been challenged. Of course, the Department of Justice is notified and has the opportunity to weigh in, and they have. Even once under the Trump administration, and said, yeah, let's interpret this statute in a way to avoid the constitutional problem. Couple more things under the Biden administration. The Department of Justice sent a letter to the Utah Department of Corrections in March of 2024 about how it handles inmates who identify as trans and where they're placed and access to medical treatments and all of the rest. And they subsequently filed a complaint when Utah didn't respond the way that the federal government wished. And then finally, and perhaps most significantly, HHS is its Office for Civil Rights is not the only enforcer of Section 504, but it's the primary enforcer of Section 504, especially when it comes to the provision of health care. And they adopted a new final rule. It wasn't just about this. It was about lots of things, but it was about this. And in the preamble of the rule, certain commenters, including our organizations, asked the question, what do you think? Is gender dysphoria a disability? And if it is, what does that mean for the interpretation application of Section 504? And they said, unsurprisingly, that in their view, gender dysphoria was a disability for purposes of Section 504, and that any effort to restrict access to the sort of medical interventions that are commonly used as treatments for gender dysphoria, that could violate Section 504. Other questions we asked them, they didn't answer. Section, the theory is that Section 504 and the ADA do other things besides guarantee access to these sort of medical interventions, but they declined to answer those.
HHS and its disability discrimination rules seem to rely a lot on the DOJ's statements and then also on the Kincaid decision. I think it's important to note that the DOJ's first letter under the Biden administration was a few months before the Kincaid decision. And so this was something that the administration was pushing. It wasn't merely a response to Kincaid as being the only circuit court to address the issue. Is there any litigation on the Biden disability rule?
Yes, the state of Texas, joined by a number of states, the rules have filed a challenge to the rule, and that's still pending. A number of other states joined it, so are co-plaintiffs. It's the states you might imagine. It's a lot of red states that joined in with this, and they're saying that the rule is invalid. They're focused on the reality, or the argument rather, that gender dysphoria is not a disability, that it falls within the exclusion of gender identity disorders. I looked at the docket sheet, and it looks like they're proceeding directly to cross motions for summary judgment. And I think initial briefs will be filed fairly soon, and the defendants will file their own motion and their opposition to the state's motion in February. We'll have a new administration in place by then, and perhaps that changeover will affect how the DOJ handles this litigation. There are also some other cases going on that involve this issue that aren't about the rule. Some of these cases I talked about when tallying things up, those were initial decisions on motions to dismiss, where it's easier for the plaintiff to win. They make an allegation in their complaint that there's a physical cause or something like that. You got to take that as true. So some of those are still pending. So I think there's going to be more litigation on this, not just about the rule, but about sort of the statutory interpretation per se.
One thing on the HHS disability rule, I do want to note that large chunks of that rule were really good and provide really important protections for folks with disabilities. A lot of what I would characterize as pro-life provisions that I think both of our organizations supported. But the one issue we had, or one of the major issues we had flagged, and I think that the litigation itself is flagging, is that expansion to apply to gender dysphoria, as opposed to all these other great aspects of the disability discrimination rule. So as we're nearing the end of the Biden administration, do you have any thoughts on what might happen under a Trump administration on this issue, or with any of the litigation?
Yeah, in the litigation context, you could see the Department of Justice conceding the case. There's precedent for that. My organization and I personally were involved in challenges to the HHS contraceptive mandate, and including challenges to the so-called accommodation, which was sort of an alternative compliance mechanism for religious entities that weren't eligible for the very narrow religious exemption. Those cases were still ongoing after the 2016 election. And when President Trump took office the first time, it took a while, but his Department of Justice ultimately just conceded those cases. So I could imagine it's at least possible for the department. I don't have any inside information, but I suppose that the department could, consider that option in the state's lawsuit challenging the rule. Of course, they will have the opportunity to revisit the Section 504 final rule that HHS's Office for Civil Rights published this year. As you said, there are elements of it that are quite good and should be maintained, at least in the judgment of my organization. But there are, this piece about the gender dysphoria as a disability, they could reconsider that. The position in litigation is something important too. When the constitutionality of the exclusion is at stake and DOJ is invited to weigh in, they need not take the position that A, the statute is ambiguous, and B, that you need to interpret it in such a way as to avoid a potential equal protection problem. To the extent you view this reinterpretation as incorrect or as a problem, obviously Congress can fix it. A rule change won't fix it by itself because you've already got a circuit court saying this is the law, right? That this is how you should interpret the ADA in Section 504. So it's at least theoretically possible that you could fix, if you want to characterize it as a problem, you could fix this by legislation. I'm skeptical that will happen, just given the need for 60 votes in the Senate. And there tends to be a party line breakdown on this issue, but that's at least technically a possibility as well.
Do you have any thoughts on how this issue might ultimately be resolved by the Supreme Court, or if it's something that the court might take up soon? Again, this is all speculation, but any insights for folks listening?
Yeah, I do think that we're going to continue to have litigation on this question. I mean, just the sheer number of cases from inmates, and we know that people who are confined have a tendency to be litigious, and so I think we're going to see more suits coming out of the prison context. Also, employment is a fertile area for disputes and litigation. So I think we're going to see more and more cases. I would not be at all surprised if we see other circuits weighing in on this question, and we might see a circuit split. There wasn't a circuit split at the time Williams v. Kincaid. The cert petition was filed in that case, and that may have been part of the reason why the court didn't take the case. But I suspect we'll see a circuit split sometime in the next couple of years. Hard to speculate how it would come out in the court. I think it's setting aside all the policy implications. It's a very fascinating question of statutory interpretation. You have a phrase in the statute and it correlates to a phrase in a secondary source, and the secondary source changes. What do you do with the interpretation of the statute? So I don't want to predict how the case would come out, but I think we'll get a case in the Supreme Court, because at least two of the justices recognize the importance of this issue, the enormous consequentiality, if that's a word, of this view about these statutes. And I suspect that other justices will, at least wherever they come down on it, will recognize that this is an important question that needs to be resolved.
It seems that if the Supreme Court forecloses application of some of the end goals through the 14th Amendment in Scrimeti, which seems to be the indication at this point, though anything could happen. And if sex discrimination in the Bostock application gets cabined to Title VII, that we would probably see more claims under the disability discrimination as another means to try to achieve some of these pronouns and access to sex-specific spaces, mandated coverage by insurance, mandated provision by doctors and medical providers. And then, as you mentioned, and as these disability discrimination laws apply to prisons. And so this seems to be a context where the other laws may or may not apply to the same degree, which is maybe why it's come up a lot in the prison context. So I think you're exactly right that we're going to see this a lot moving forward. I also think that there might be related claims in the state context under state disability discrimination laws. I don't know if you have any insights into if there's been movement on the state front under state laws.
Yeah, there are a lot of states forbid disability discrimination in various contexts, employment, public accommodations, and the rest. Some of them use the federal definitions. They take the language from the ADA in Section 504, and some of them import not just the basic definition that we talked about at the beginning of our conversation, but also the exclusions, including the exclusion of gender identity disorders. And, a lot of times courts will say, we're going to interpret our analogous state statutes consistently with how the federal statute is interpreted. So at least the foundation has been laid for reinterpreting state laws and local ordinances that forbid disability discrimination to reach gender dysphoria and to generate the kind of results dealing with private spaces and sports and healthcare and health plans and pronouns that we've been talking about so far. I'm not sure that it's happened yet, but I'd be very surprised if we don't see it soon, where there's an effort to, again, reinterpret a state law or a local ordinance in this manner.
We've seen this in the abortion context. After Dobbs, a lot of the litigation moved from federal litigation to state litigation. I suspect that if this issue is foreclosed federally, there'll be a massive shift to state laws in litigation there. As we're wrapping up, Greg, this has been excellent. I've learned things, even though this is a topic that I've researched and studied some myself as well. Do you have any final thoughts or anything else you'd like to say for everyone listening?
Well, I think one thing is that interests me a lot is, the pursuit of objectives in multiple ways. The Equality Act has been introduced in the past several Congresses. And one of the things that it would do if it were, again, the Equality Act essentially would add sexual orientation and gender identity as protected characteristics in a number of federal anti-discrimination laws, including Title II of the Civil Rights Act of 1964, which is about public accommodations, and Title VI, which is about recipients of federal financial assistance. Neither of those existing laws include the word sex as a protected characteristic, so they have not been susceptible to the reinterpretation that we've seen in the Title VII context, the Title IX context, the context of the Fair Housing Act, the context of Affordable Care Act, Section 1557. So, they're just that avenue has been closed off. But if the term disability includes gender dysphoria, and in a sense, gender identity, the reinterpretation will achieve the Equality Act's goal of amending Title VI, which again is a ban on discrimination on the basis of certain characteristics by all recipients of federal financial assistance. So, the Equality Act did not have success in Congress, but I think it's being in some ways being achieved, or at least trying to be achieved piecemeal through administrative and regulatory reinterpretations, fair housing, employment. And I think this phenomenon that's happening right now is essentially an effort to enact the changes that the Equality Act would have made to Title VI.
Well, this concludes this episode today. Thank you, Rachel and Greg, for joining us. We appreciate your time. And for our listeners who wish to listen to more episodes like this, please check out our website, fedsoc.org.
On behalf of the Federalist Society's Regulatory Transparency Project, thanks for tuning in to the Fourth Branch podcast. To catch every new episode when it's released, you can subscribe on Apple Podcasts, Google Play, and Spreaker. For the latest from RTP, please visit our website at regproject.org. That's regproject.org.
This has been a FedSoc audio production.